Well, now we're going to go over into the, as we still continue to move along with copyright, we're going right into the internet area. Well, let's take a look at internet issues, copyright,
Fair use.
and fair use.
Can everybody hear me? I don't know if I'm supposed to get this closer.
Go right ahead.
Okay, let me try and get it closer. I'm too short for this. All right, don't read anything into the subject matter here because I did not volunteer for the next two cases. I was assigned. Perfect 10 is the plaintiff in our next case. This comes out of the United States District Court of Appeals for the Ninth Circuit. Perfect 10 owns, markets, and sells copyrighted images of nude models. And Perfect 10 also operates a subscription website where subscribers pay a monthly fee to view Perfect 10's nude images. And they also licensed an entity to sell and distribute reduced-size images for download on use on cell phones. Perfect 10 claimed that Google and Amazon impermissibly facilitated access to infringing images of Perfect 10's photographs by displaying thumbnail versions of the images on their search engine website and by linking to third-party websites that displayed infringing full-sized images. The Ninth Circuit affirmed in part and reversed in part. The district court had issued a preliminary injunction for some of the activities that Google was engaged in. The court held that in seeking preliminary injunctive relief, Perfect 10 had the burden of showing not only likelihood of success on the merits, but also, once raised as a defense, a likelihood that it could overcome defenses raised by the non-moving parties, and the fair use defense was raised. On the issue of direct infringement, the Ninth Circuit agreed with the district court that Perfect 10 was likely to succeed in its claim that Google's thumbnails constituted direct infringement of the right of display, but said that Perfect 10 was unlikely to succeed in overcoming Perfect 10's fair use defense because the use was highly transformative and provided a social benefit. The court found that Perfect 10 had failed to introduce evidence that Google's thumbnails harmed the market for full-size images, and the fact that Google made a significant derived a significant commercial benefit from its use of the thumbnails did not sway the court against a finding of fair use. The Ninth Circuit also agreed that Perfect 10 was unlikely to succeed in its claim that Google's inline linking to full-size infringing images on other people's websites constituted an infringing display or distribution of Perfect 10's images, and it had the same finding as to Amazon. On the issue of secondary liability for infringement, the Ninth Circuit reversed the district court's holding that Perfect 10 was unlikely to prevail on its contributory infringement claim and remanded the issue for the district court to consider whether Google had knowledge that infringing Perfect 10 images were available using its search engine and could take simple measures to prevent further damage to Perfect 10's copyrighted works and failed to take such steps. The same analysis had to be taken for Amazon as well, so there was a remand on that issue as to Amazon. And then finally, the Ninth Circuit affirmed the district court's holding that Perfect 10 was unlikely to prevail on its vicarious infringement claim because Google and Amazon lack the practical ability to police the infringing activities of third-party websites. And because they have no control, the court did not consider the extent to which Google may have received a direct financial benefit. That's
Now,
Perfect 10.
Now, this is interesting because that's a
Slog through fair use.
Ninth Circuit case, and on the issue of that, the court finds that the use of the thumbnail-size images is a fair use because we've had, we can compare that to the Second Circuit ruling on Bill Graham Archives from a year or so ago, v. Dorling Kindersley. That's where there was a book called The Grateful Dead, The Illustrated Trip, and the defendant, writer and publisher, had used posters of Grateful Dead concerts owned by Bill Graham Archives, but put them in thumbnail-size images in the book. This was not on the web, but in the book, but it's the same kind of idea. There seems to be, and in that case, thumbnail-size images, a chronological history, and juxtaposing the images created a transformative use, and it was fair use. So here we have the Second Circuit in the Bill Graham case, and the Ninth Circuit on a similar issue in the Perfect 10.
Both finding fair use.
Yes, both finding fair use.
So the next case is way more fun. Burnett versus 20th Century Fox Film Corp. In that case, the show The Family Guy, which routinely lampoons celebrities, aired an episode entitled Peterotica, where the family patriarch, Peter Griffin, that's my neighbor's name, enters a porno shop with his friends and remarks that the shop is cleaner than he expected. One of his friends explains that Carol Burnett works there as a part-time janitor. And the show then switches to a less than 5-second scene of an animated figure that resembles the Charwoman character from the Carol Burnett show, who's mopping the floor next to blow-up dolls, XXX movies, and a curtained room with a sign above it that says video booths. As the Charwoman mops, a slightly altered version of the theme song from the Carol Burnett show is playing, and Carol Burnett was not amused. She filed a lawsuit asserting copyright infringement, a Lanham Act violation, trademark dilution, and common law right of publicity claims. The very sympathetic court, after considering all of the fair use factors, nonetheless held that the work was clearly a parody and as such transformative, that while the nature of the copyrighted work was clearly expressive, that was not much help because parodies almost invariably copy publicly known expressive works, that the show did not take any more of the Charwoman's character than was necessary to place the image in the mind of the viewers, and that the demand for the original copyrighted work would not be supplanted by the use. So the court found that there was a fair use and no copyright infringement. On the Lanham Act claim, the court said that there was absolutely no likelihood that viewers would be confused into thinking that the use of the Charwoman character was actually authorized by Carol Burnett. And the court said that the more outrageous and offensive the parody, the less likely any confusion will result. And then went on to say how offensive the parody was. Because the parodied work was non-commercial speech, it was not subject to a trademark dilution claim. And on the state law privacy claims, the court then declined to exercise supplemental jurisdiction and basically said if you want to pursue that, go to state court. So that's Burnett.
Let's get this right, though. What we have here in this case is a comedian filing suit against a comedy show. I just want to get that out there. But it's another example of transformative use at work.
Yes.
It's a strong part of the fair use analysis, obviously.
I mean, maybe it's possible that as you age, your sense of humor declines, diminishes.
Pardon me?